Well, hello, everybody. I'm Yoon Cannon, and I'm excited for today's guest. I have Anthony Verna the third here talking to us today. He's an IP attorney, and I think this is such an important topic because as entrepreneurs, as CEOs, uh, you get so engrossed in your business and you forget about your intellectual property, or you just assume because you registered a fictitious name that you're good, and nobody else is going to infringe on that. So I love how Anthony's area of expertise is, everything. It just spans from the whole domain disputes to copyright and trademarks. And then, of course, yes, there's a lot of our audience who are creating some innovative products and they're trying to get it to market, but they're doing it without having their products patented. So we're going to pick your brain today. So Anthony, welcome. And can you give us your 60-second elevator pitch?
Thanks, you, and it's a pleasure to be here. So Anthony Verna, yes, the third, named after my father and my grandfather. Managing partner of Verna Law. We are a three-person law firm located north of New York City in Westchester County. We focus on intellectual property and advertising law. So that means patents, trademarks, copyrights, domain names, name, image, likeness rights, and we are full service in that area. So that means we help with due diligence. So because at the beginning you need to be really defensive about it and do your due diligence. You need to do your research. You need to understand, regardless of what you're registering, what else is out there. Through the prosecution process, and when we say we're applying for a patent or a trademark or a copyright, we call that prosecution. So we do that entire process as well. If you need to license or you need to become a licensee, we can help with those particular contracts. And yes, should there be an infringement, we can help with litigation as well. On the advertising side of life, we help companies work with ad agencies. So that's mostly contract review, understanding the contract, understanding the liabilities, understanding budgets if your contract needs to set budgets, understanding SAG-AFTRA agreements if you're going to be creating something, a longer campaign, with actors, with writers. We can help with that. And we can review the content of advertisements for state federal compliance. We also draft sweepstakes and promotion rules, so if businesses are giving anything away and creating a game around it, we can make sure that you're compliant in as many states as possible. And that can get a little complicated because we have 50 states, we have several territories, we have DC, and they all have different laws regarding it. So we do our best to make sure that our clients are compliant, because the last thing you want knocking on your door is any state attorney general because you didn't follow rules in a game. So that's the overview
Wow,
of everything that we do as a three-person firm.
that's a lot. And it's interesting that you even bring that up because in my world, I do so much marketing for companies and gamifying
Yes.
gamifying something, within your marketing, just to make it fun, to invite people to a challenge. And I bet it has not even dawned on many, many people, including myself, that, that you could get in trouble with compliance. Can you give us maybe just a couple of specific examples of, what kind of compliance pitfalls, a
Sure.
specific area
Sure.
that
Sure.
you've come across?
Yeah. Yeah. That's actually pretty easy to come up with
Yeah.
examples. But if you're giving away more than $5,000 or a prize worth more than $5,000 in New York and Florida, you actually have to register your game with the state. New York requires you to have the prize value bonded. Florida
Really?
doesn't. Yes. Yes.
All right. So
Florida.
let's say, let's backtrack for a second and give
Sure. Sure.
people some context. So let's say the business is planning on showing up to a trade show. And at
Right.
that trade show, they want to make this big splash and they're going to do a giveaway of some amazing
Right.
thing, maybe a car, maybe something smaller. But
I
yeah,
I I
so let's
I
say it's
did a
valued
set
at,
of rule. I did a set of
yeah.
rules for a company giving away a car not that long ago. Yes, it
So whether,
happens.
I mean, that's pretty big a car, but if it was even something, $3,000 range or maybe multiple prizes. So you're saying they actually have to be careful. They could fall into some compliance issues with
Yes.
their gamification, because the game is usually, something about fill out our card. And
Yes.
does that count as a game? Fill out your
So,
info
well,
for like a ticket for a chance to win the
absolutely.
prize.
Absolutely. That is right there a part of the games that we handle. So yes, if you're giving away a big enough prize, you have to make sure, and you have to make sure, like I said, in New York, the prize money would have to be bonded. In Florida, you just have to show proof. So, excuse me, if your game is
Hmm.
is going to be in Florida, Florida's happy if, say, the money sits in your attorney trust account. That's fine. But for New York, it has to be bonded. And in Rhode Island, if you're a retailer, then you have to register. They don't really care about money. They just care that if you're a retailer or not. In some states, you have to give very specific odds about winning. Other states, your rules can just say one in the odds of winning are determined by the number of entries received. All states require you to have what we call an alternative means of entry. So, for example, if you're doing something digital,
Hmm.
then your your alternate means of entry could be, on a postcard, sending in a postcard. It's not something to that effect, but you always have to have some kind of alternate means so that, of course, as we know, no purchase is necessary, and items like that, so that it's not effectively you paying for a chance to win, because if you're paying for a chance to win, we call that gambling. So that's really
Mm.
what am I
Yeah.
doing? I'm making sure that my clients who are giving away, things in exchange for information, right? Because
Right.
businesses want information of their customers or clients.
Hmm.
So creating email lists, creating all of those advertising emails that we receive. If it's being done in exchange for the chance to win a prize, we want to make sure that we're staying away from all of those gambling statutes, and that's the key.
So give an example of what the consequences would be if they didn't do all of that.
Well, the consequences could be an investigation from the state attorney general's office, and you want to make sure that you're staying away from those kinds of investigations. Every state has different levels of punishment, civil fines for not following the compliance, and that can go from, what are some of the other issues on compliance. You could maybe you didn't publish the rules, maybe you didn't have a set of rules, which would be a big issue. Maybe you didn't publish the names of the winners of your game. um I think it's only Tennessee that allows
Hmm.
people to decline from being published as winners in a game, but every other state requires you to publish winners. So um the
So would you say the fines are hefty, or is it just a little slap on the
well,
wrist kind of a fine,
right.
like a
And
parking ticket kind of a
yeah,
fine?
and I think that's where a lot of businesses kind of roll the dice and play craps with
Hmm.
with these particular games, because I think a lot of them don't see that first time fines are all that heavy. But that said, I still would rather,
Sure.
you not. Yeah, no, I think what's harder is dealing with getting the letter that a state's investigating you for an advertising violation. I mean, especially when
Yes.
it's not that hard to draft a set of rules that are compliant, or even a set of rules that are like most of the way compliant, because, like I said, we have 50 different states and 50 different sets of rules. As we joke in the advertising law business, no one set of sweepstakes is going to be compliant in all 50 states. It's
Right.
just kind of a fact of it. But if you at least have a set of rules, and you're talking about your alternative means of entry, you're talking about how there's no what we call consideration, so there's no payment, there's no purchase necessary and you're talking about the odds of the game and how the game works. At least if you do that, you're
Right.
75% of the way for being safe. So putting a little bit of investment means having defenses should you get some kind of query from the state attorney general's office.
Yes, you don't want to have to deal with that. It's negative headspace. It's more time. So I'm still a huge proponent in that example, coming from a marketing standpoint. Yes, I think it's great to have
Yes.
something fun to do, to
Yes.
gamify, to get people to come to your booth. But for the folks listening, please go check it out with an IP attorney. And we'll be sharing Anthony's website at the end. Well, it's vernalaw.com,
Yes.
but he'll be
Yes.
sharing your contact information. All right. So shifting gears into another scenario, some of our audience, they have a really novel product and design, and they have already gone to market, many of them, and they're just trying to get traction because part of that process of getting funding is to show your investors,
Yes.
how it's going, what's
Hmm.
the demand out there, what's the initial sales. But they didn't do, a lot of entrepreneurs just aren't yet getting the patent stuff together. So talk to us about how can you help, do you help people when somebody else sort of swoops in, takes their design idea, and
Well,
then
well,
goes and gets that patented? Is it, or is that just too late at that point?
well, it might be too late at that point. So I always say, so let's take a step back. And I always say, when you have your new, product, ready to go, first question is it protectable? So is it something that is new, novel, and what we call not obvious? That's the first questions that we ask. And now in the software space, the Supreme Court added another question: is there an inventive step involved? I don't really know what that means, and I don't think the Supreme Court knew what it meant when they wrote that opinion. But that's what we have to deal with. So is it new? Is it novel? Is it something that hasn't been done before? And I know that a lot of people say, call me and say, oh, nobody's ever done this before. But truly, is it truly new, truly novel? And then the other question is it not obvious? And what that means is let's suppose that patent A, discloses something, and then patent B discloses something. And if I can take A plus B and I can make C, and what you've given me is C, that's obvious, theoretically. So
Mhm.
there are times when you can argue about that. By the way, going from, say, the headphone size that I'm wearing to the earbuds that you're wearing, a lot of people, when headphones first went, small, the Patent and Trademark Office said that is obvious because all you're doing is making something smaller. So you had to fight for it not being obvious. Why? Well, because miniaturization just was harder to do. And getting something smaller doesn't necessarily mean that all you're doing is taking, a bigger thing and you're making it smaller. No, you actually have to, figure out how to get sound quality. You have to figure out how to, create the wiring, that's inside, especially, in something like earbuds where everything is wireless. So there are times when you argue about what is not obvious and what is obvious. So those are the questions that we ask on the due diligence side before we ever file. Now, if somebody has taken your product that is new, novel, and not obvious and started making it before you filed a patent, well, the first question is has your product been in sale or been in public disclosure for more than a year? Because if it has, you will not be allowed to file a patent on it. You only have a year from your first public disclosure. That change is not really new. It was made during the Obama administration with the America Invents Act, which made America go from a fairly unique patent scheme, including protecting those who invented a product first, to going to lining up more with the rest of the world. A lot of European countries, Mexico, Canada, and Asian countries generally protect those who file first, and that's basically what the America Invents Act did. Is it kind of made us in line more with the rest of the world. So If your product has been on the market for more than a year, you will not be able to patent it, even if it is new, novel, and not obvious. Two, if somebody else has filed before you, you will not be able to get your patent, even if it is new, novel, and not obvious. You must file first. It is now a race to the Patent and Trademark Office to file your invention. So, if somebody else has, taken your particular product and started copying it and you don't have a patent on it, the question is, what else can you do to protect it? Some products will have aspects of copyright law, which generally protects works of art. And so maybe there's some kind of protection there. If the branding is exactly the same, maybe trademark law is able to help you as well. If despite the fact that it's something for sale, is there something inside that is a trade secret that could only really be, reverse engineered or something to that effect? But trade secret law tends to be not highly helpful if you're selling a product for public use. So there are things that can be done, but yeah, really doing it, getting your patent filed early is the most helpful, because even if it takes 3 or 4 years to get your patent in your hands after filing the application, at least you can retroactively go back in time when you file, in court, and you can say, well, they've been infringing since the day I filed, and you can go back to the day that you filed with your patent in your hand.
Wow, that's huge.
It is.
I'm sure a lot of our audience, doesn't realize that, and that's really key information that they can take away. They've
I
got that
hope I
1 year
didn't melt too.
mark.
I hope I didn't melt too many synapses with that paragraph.
No, no, not at all. But I think that's very easy to remember. You got 1 year after you went to market, and I love, just the fact that it's first to file, that has a lot of leverage. So
It
there's some
it, it
urgency to get that filed
yeah,
and filed correctly, I would imagine, right? Having it
well,
filed
yes.
correctly.
Yes, of course. But yes, that 1 year is something that, despite the fact that the Obama administration was now 3 presidents ago, there's still a lot of lag time about entrepreneurs not really understanding that urgency has been in existence, and that urgency is not new, but that urgency is there.
Wow, there's so many other topics and scenarios I think we could talk about, but this is just a short introductory video for people to get to know who you are, Anthony. So for folks who are looking to figure out, which IP firm to hire, what's your advice as far as 3 things business owners should look for when looking to hire an IP attorney?
Well, I would say the first one is, it somebody who understands you, and I say that whether it's your doctor, your therapist, your lawyer, when you're dealing with a professional, is it somebody who um, knows you, understands you, and somebody that you think you can get to know, because with all my clients, there are ups and downs regardless of the situation. You're coming to me for trademark litigation, and you never filed your trademark from the beginning. Well, we're going to have some ups and we're going to have some downs, so you have to understand that particular relationship, and you got to be simpatico with the firm that you hire. So number two, is it somebody that really does what you're looking for? And in that particular instance, I don't necessarily mean, is it an IP firm? For example, if you're coming to our firm with maybe something in chemistry or bio life sciences, I'll tell you, we're probably not the firm for you, because my bachelor's is in computer science. Our patent agent has his bachelor's in mechanical engineering. I programmed before I went to law school. He worked as an engineer for the Navy before he became a patent agent. So we have some excellent experience behind us, but we're not really going to be able to write that. We're not going to be able to write that chemical equation in your patent application. So we're not going to be simpatico for you from a technology standpoint. But you come to us for anything else, and we can handle it very well. And I would say the third is, I hate to say rates, but a firm like us, we have, we're three people, we have less overhead. We're able to charge less money. I remember speaking to somebody who had rolled his eyes and got angry because he had spent $60,000 on some patents, and I said we could have saved you, at least 30. As ridiculous as that sounds, we probably would have saved that startup $30,000 from the very beginning. They just, to them, they wanted to go to a bigger firm. They thought that the bigger firm meant more. And we've had people who called us and talked to us and decided that the bigger firm was their value proposition despite paying more, and that's fine. Um, we, like I said, sometimes that doesn't, sometimes part one and two matters more than part three, and that's perfectly fine. You got to make sure that you're comfortable with who you choose. And but I would sit there and say, one, personality, to make sure that you're simpatico; two, technology, to make sure that you're simpatico; and then three, of course, on the rate.
All right, great tips there. And how can our audience get in touch with you?
Sure. You can find us at Verna Law. So my last name, VERNALAW.com. You can reach me, Anthony at vernalaw.com, in email, and you can call our office 914-908-6757. So yes, we actually have a landline with a receptionist. I know that's really
A
old school, but
landline. Wow.
I know.
Imagine that. And they answer their phone. I love it. I love that. So as we wrap up, can you share a fun fact about yourself as a person?
Oh, as a person.
Mhm.
Oh, I thought you were going to ask for a fun work story, but fun fact as a person, I play tuba.
Tuba. No kidding. Do you still play?
It's been a while, but I'm actually
Uh-huh.
it's funny since I'm actually getting it repaired next week, so that I can pick it up again. My conductor from college, he and I are still friends, and he texts me every once in a while if I've
Uh-huh.
gotten it fixed. Usually he texts me about football, but he's
Yeah.
texted me recently, again bugging me about getting fixed, and I actually found a repair shop that, not that I just trust, but we actually have friends in common,
Mhm.
which was kind of funny. So I found somewhere that I finally trust getting it repaired. So I'm getting it repaired.
Yeah.
I'm picking it up again, and watch out, Brass World.
All
I'm come
right.
I'm coming
We'll have
back.
to post you'll have to post your tuba performances. That's awesome. Well, thank you so much, Anthony. I really appreciate you sharing just actionable, insightful tips with our audience today. And there's definitely a lot to think about. And I just want to encourage folks out there to go and get in touch. Make sure you've got the right attorney by your side for your business. Thanks again, Anthony.